Good afternoon, everyone. It's 12:01 on my clock, so I think it's a good time to get started. Today, as you know, our topic is going to be all about collective bargaining and specifically the contract terms. I'm glad we have such an enthusiastic turnout today. As we said in the promotional literature, this is really useful information for anybody on a board, whether or not you serve on your negotiations committee, because ultimately you do have to approve the contracts and work with them throughout your term. So we are delighted today to have two special guests with us. We have Chris Leopold and Colin McNeil, both attorneys with McNeil, Leddy and Sheehan. And they are really experts in the school board positions in collective bargaining. They both consult with many of the boards in Vermont, and we're so pleased to be able to have them join us today. So with that, I am going to make myself disappear, and I'm happy to open this up to Colin and Chris and the wisdom of their ages.
So just a quick note, the presentations for the benefit of the audience, it shouldn't be construed as legal advice, and if you need specific legal advice about a matter, please contact your school attorney. The issues associated with collective bargaining are complex and specific and should be analyzed on a case-by-case basis. This afternoon, we're going to, we have time to review bargaining timelines. We're going to talk about collective recognition clauses in both teacher and support staff contracts, management rights clauses, subcontracting clauses, association and union rights, teacher and employee rights. We're going to be talking about salary schedules, and then we've allocated about 10 to 15 minutes for your questions this afternoon, and we hope we have time to answer all the questions that you have.
Okay, so we're going to begin by just giving a kind of a brief overview of a timeline in a typical negotiation of a collective bargaining agreement. We find it's helpful to do this just usually when we meet first time with boards, or we meet with clients who haven't done this in a little while, just to kind of get a refresher on how the process works. So we're going to go through this pretty quickly. I think we could spend a lot of time obviously on this process, but we're going to go through it pretty quickly. So the first step is negotiations. So the negotiations would be initiated by either the union or the district, and they are to begin by statute for teachers or administrators 120 days before the budget vote, and they could also be initiated per the terms of a contract. So oftentimes you'll see a contract which specifies when negotiations are going to begin. Now, negotiations are controlled by, there's the Teacher Bargaining Act, Teachers and Administrators Bargaining Act, and there's a Municipal Labor Relations Act. Oftentimes you'll see more specificity in the Municipal Labor Relations Act, and you're going to see at times that the Vermont Labor Relations Board will look to that act for guidance as to uncertain issues. One of these is how long you have to negotiate before the next step, which is impasse. The Municipal Labor Relations Act identifies that negotiations must be engaged in good faith for at least 60 days before either party can declare impasse. Now, an impasse is essentially, it can mean a couple different things, but it's generally that the parties have engaged in good faith negotiations on the issues they're required to bargain about, which is wages, hours, and conditions of employment, essentially. There's other topics that are included in the Teachers Act, such as how to handle grievances. But if the parties are unable to reach agreement after engaging in good faith negotiations, the parties can declare impasse. And the next step, once you have declared impasse, is what is offered in the statutes is mediation. Now, mediation is not mandatory. It is a process that the parties would agree to meet with a mediator and engage in essentially what has become shuttle diplomacy, which means a couple different things. One, in times when we're not engaged in the virtual world, the parties are in two separate rooms, and a mediator would go back and forth between the two to try to resolve the conflicts. In Zoom and virtual world, it's essentially the same thing, except the parties are in two separate virtual rooms, and the mediator will go back and forth. Now, the mediator doesn't settle a dispute. The mediator just tries to assist the parties in reaching a resolution. However, if that is unsuccessful, and or the parties have elected not to engage in mediation, the next process in the timeline is fact-finding. Now, fact-finding is mandatory under the statute, and you can actually, well, we'll keep it here. Fact-finding is mandatory under the statute, and this is a process by which the parties are required to submit their dispute on issues that they're required to bargaining to an independent fact finder who will make a recommendation on a resolution. The fact finding process is not binding. However, the fact finder will hear the parties' arguments on those issues that are in dispute and take them into consideration, and then issue a recommendation on perhaps how the parties can settle their dispute. 30 days after the fact-finding process is concluded, that might be after the hearing is finished or after the parties have submitted post-hearing briefs, the fact finder is to issue its recommendation in writing. And so what you have is 10 days following the receipt of that report. That report is confidential and cannot be shared with anyone else. It's not subject to the public records requirements. It is a private document for a period of 10 days. And during that 10 days, the parties should engage in negotiations to discuss the fact finder's recommendations and how the parties should work towards resolution. That can sometimes mean that a mediator is brought in. It can sometimes mean the parties just talk about it and try to work it out. But they should try to meet in those 10 days to try to address the fact finder's report. 30 days after the fact finder's report is issued is when the parties can either engage in a strike on the part of the employees or impose a policy of finality by the employer. And if you can actually move a couple slides ahead to page 6. There we go. So this is the process we're at now. The fact-finding report is public. And if you move to this following slide. Oh, one too far. So what you see here is that with finality, you're going to see that usually what the parties would do before a declaration of finality is declared is they try to meet and resolve the differences. If that's unable to be done, finality can be declared. The employees could also have a strike vote and go out on strike. With finality, it will bring the negotiations to a close, but it does not end a strike. And finality can be imposed whether or not a strike is occurring. And a strike cannot, finality cannot result in teachers paying money back. So for instance, with step movement in teachers, for example, if teachers move on step per the contract, but the finality is imposed after that date, a school board cannot recoup monies that have already been paid. It can only address issues in the forward. So essentially, and once finality is imposed, and unless other terms are agreed to, that is the conclusion of the bargaining process. So a very quick overview of the timeline of negotiations, but essentially that is it. So next I'll have move to Chris to talk about recognition clauses.
So recognition clauses are one of the fundamental elements of your collective bargaining agreement. Every collective bargaining agreement in the state has a recognition clause. And it really does two things. First, it identifies who's the employer and who's the bargaining unit representative. What's the name of the union? What's the name of the association that is representing those groups of employees? The second thing that a recognition clause does is it defines who's in the bargaining unit. Simply put, it's a statement of who's in and who's out. And some recognition clauses are very simple, and others are more complex, depending upon both the employer as well as the nature of the employees that are being represented. There's a relationship between the recognition clause and the petition that a union or an association filed at one time before the Vermont Labor Board for the bargaining unit to be recognized. And in that petition, they had to specify what types of positions are going to be in this bargaining unit. The importance of the recognition clause really changes over time based on both the size, the complexity of the nature of the school districts as it evolves over time, and the nature of the employees that work for the district change. Next slide. Here's a sample teacher clause, and when you read it, you can see it's a fairly old recognition clause, and one that I would say is sort of old school, and it defines the bargaining unit of consisting of all classroom teachers and school nurses employed by the board. And you know, one question that arises when you look at this are Title I teachers part of the bargaining unit? Are guidance counselors part of the bargaining unit? Special educators and other types of licensed teachers or educators who aren't classroom teachers? And in all probability, the answer is yes, but that's not what is reflected in the recognition clause. If you move on to the next recognition clause, you can see in this recognition clause that's more complex from a teacher contract that the parties were trying to do several things. First, it consists of all licensed personnel holding a valid license from the AOE. Secondly, the teacher must hold a position for which licensure is required, either as a prerequisite established by the state board, the school board, or by the state of Vermont. So if the position doesn't require licensure, it doesn't matter whether the individual has a license. They're not covered by this recognition clause. Additionally, at the bottom, this recognition clause specifically excluded certain types of licensed educators. So for example, it excluded directors of guidance. It excluded school psychologists who are licensed by the Agency of Education. And it also excluded occupational and physical therapists, substitute teachers, and non-instructional coaches. So if you have someone who is hired as a coach that has a license, and their role as a coach is to work with teachers, they're not covered by this bargaining unit clause, they're outside of that, as opposed to an instructional coach that may be working directly with students. Next slide. Support staff clauses also vary. The clause that's in this sample is what is regarded as sort of an A to Z clause. And that means that what this clause does is it zips up everybody who is employed by that district as a support staff employee that isn't specifically excluded. So for example, it says all support staff, including but not limited to, and then it lists certain types of positions, but those positions are for informational purposes only. It's not a exclusive list. And then at the bottom, it says, but excluding all supervisory, confidential, or employees working 15 hours or less per week. So under state statute, you have the ability to exclude supervisory or confidential employees. And the tests for those are established by the labor board. You also can set a threshold at which an employee has to work in terms of the number of hours per week. And if they don't work that number of hours, they're excluded from the bargaining unit. Part of the rationale for that is that an employee working 10 hours per week has different interests than an employee who's working 40 hours per week. That their employment level may not justify being in the union. Next is another sample support staff clause. And this clause goes on to name, it's from a supervisory union, and it names the types of positions that are in the bargaining unit by district, because that varies. So in this contract, supervisory union paraeducators are in the bargaining unit. And then in one district, the general paraeducators and the custodians and administrative assistants are, but excluding the assistant to the principal, who's a confidential employee. And then it goes on to name other positions and to exclude, again, assistants. So those are the basic types of things that are done in your recognition clauses. Next slide. It's really important to be thoughtful about these when you're looking at it, because your needs as an organization can change over time. And even when you have a clause that excludes certain types of employees, the union always has the ability to, one, say, well, we excluded custodians from the unit 5 years ago, but now we want them named. And they can do that two ways. They can do that in negotiations directly with the board, or they can do it alternately by filing a petition with the labor board. You also want to be careful about whether or not central office employees are included in the bargaining unit. Are you excluding specifically confidential employees, supervisory employees, and then non-licensed directors and professional employees, such as a social worker, for example, who isn't licensed by the AOE, but is licensed by the Secretary of State's office? And are you excluding seasonal and temporary employees from being in the bargaining unit? But those are specific issues that you really want to make sure your recognition clause addresses. Next slide, Colin.
All right, thank you, Chris. So I wanted to talk a little bit about management rights. Generally, what you'll see in a contract is a management rights clause, and for employers, management rights clause is a key component because it really for the employer, for the school board or the administration. It reserves and identifies their rights as the employer to operate the school and to carry out operations that aren't otherwise discussed or addressed in the collective bargaining agreement. So what it is it's a statement, and it also addresses those instances where the contract isn't necessarily clear as to what should take place and what the employer's rights are or what the employer's rights are. For instance, it deals with an employer's rights clause would deal with assigning work, controlling hours of work potentially that's not otherwise addressed in the contract. It's the reconfiguration of the operation. It covers a broad swath of what an employer and the school board would be able to control. Now, what we've seen recently in the management rights and the Vermont Labor Relations Board, what we've seen is that over the course of time, there's been more focus on having a more specific management rights clause. Generally, what you see in a lot of contracts is a 1 or 2 line statement, which is very broad and reserves essentially all other components of operations that aren't otherwise addressed in the contract. It reserves them with the employer. And what we've seen is that that has been addressed somewhat, so that in instances where the right is more important, like for instance, the more important a right is, the more it should be specifically addressed. Because what the management rights clause does is it reserves those rights that what I said is aren't specifically included in the contract, but by statute, because you're supposed to bargain collectively for wages, hours, and conditions of employment, it would reserve those things that aren't addressed. So those issues of wages, hours, and conditions of employment that aren't specifically addressed in the contract, with a broad management rights clause, would be reserved for management to address issues relating to them. But essentially, the more important those rights are, more involved or specific they are, the less likely the board will defer to a broad management rights clause and will look to specifics. So if we can go to the next slide. This is what you would see as a broad management rights clause. Look to the last line here. It says the board retains all rights and powers that it has or may hereafter be granted by law and may exercise such powers at its discretion. So this is a broad management rights clause that you'll often see in a contract. And if you can go to the next slide. This is a more specific management rights clause that addresses specifically what management can do or employer can do that's not addressed in the contract. So just for instance, if you look at A, it's to hire, discharge, discipline, layoff, recall, transfer, promote, and demote employees. That would be reserved for management, of course, with the restrictions that are otherwise contained in the contract. It also allows you to reassign work and require overtime, and all the other examples that are established in there, and effectively allows you to run the operation with those areas that aren't covered in the contract. It also addresses those situations where the workplace has changed. Contracts can only address so much, and there's evolutions in the way workplaces are run and the needs of a school district or supervisory union that a contract often doesn't keep pace with. So a management rights clause would allow the management and the board and the administration to address those new situations that come up during a contract, during the period of a contract is in effect. So for instance, changes in the workplace, changes in types of employees that are needed, changes of classifications of employees that are needed, all can be addressed through a management rights clause. One large component of a management rights that has effectively been addressed by the Vermont Labor Relations Board that should not be addressed in a generic 1 or 2 line management rights clause is subcontracting out. If you can move another slide. And another one. So subcontracting work would effectively be work that the union the association has taken up. However, in some instances, it's appropriate for an employer to, due to the nature of the work that's needed, the term of the work that's needed, any number of factors to specifically find someone else who's not part of the union to engage in the work. For instance, you'll just see here the work is for a temporary duration. It's seasonal work, work that would be conducted, but oftentimes you might need more hands during the summer to do certain work. A subcontracting out clause would be required in order to have the right for an employer to be able to engage in that. Otherwise, effectively, as it's been determined that this is a major area, it should not be subcontracted out. Work should not be subcontracted out without having such a clause in the agreement, specific clause in the agreement. And effectively, I'll turn it over to Chris for the next slide.
Great. We should be on page 20. There we go, 21. Association and union rights. This area generally defines the rights of the association consistent with state and federal laws regarding what information, what rights, what responsibilities does the union have relative to representing the members of the bargaining unit. And generally, you'll see the following rights appear in collective bargaining agreements in Vermont. The ability to access the employees, whether they're teachers or municipal employees, at reasonable times at their workplace. To be able to use institutional bulletin boards, mailboxes, or other communications media subject to reasonable negotiation regulations by a school board. To use school facilities at reasonable time for the purpose of conducting meetings. Throughout the state, local associations meet at their schools on a monthly basis in most districts. And mailboxes, school mailboxes are routinely used, and electronic media, email is used in most districts in the state by local associations. Next slide. This past fall, the legislature approved a new set of union rights, and the governor signed into law the act, and it provides the associations and unions throughout the state now have the ability to meet with each newly hired employee in the bargaining unit to present information to them about the union, and that's protected under Title 16 and under Title 21, which is the Municipal Labor Relations Statute. The employee is entitled to be paid for attending that meeting at their regular rate of pay. Next slide. Within 10 days of hiring a new employee, the school board's obligated to employ the union information regarding the new employee, such as their name, job title, work site, their work telephone number, email address, home address, personal email address, personal cell phone numbers, and their date of hire. The personal information regarding email addresses, cell phones, and telephone information is not subject to a public records request. Next slide. On an annual basis, or more frequently if the union and the school board agree, the district shall provide the union with a list of all employees that are in that bargaining unit. So some unions are asking for that on a quarterly basis, so they're able to update their membership rolls, reach out to people, and have the ability to contact them and say, hey, we're representing you. We'd like you to be paying dues. Please pay dues. Most contracts now include provisions for the payment of association dues. In Vermont, the vast majority of contracts used to include special provisions for the payment of agency fees, but those provisions have been taken out since the Supreme Court ruled that they were unconstitutional. They also have the ability to use school equipment during non-working hours, subject to reasonable regulation by the administration. Next slide. Before we go on to teacher rights, most of the union rights related to data information and the ability to contact employees have not found their way into collective bargaining agreements since the legislature just established those rights last fall. I think you'll see a number of those show up in collective bargaining agreements over the next several years as the local associations begin to negotiate those provisions into your contract and to do those types of things. Colin?
Sure. The next topic we're going to hit on is teacher and employee rights. So if we can go back one slide. All right, so either through contract or through statute, teachers and employees of school districts have certain rights. One of those rights would be a right to organize, which is you have the right to join or not join an association for purposes of collective bargaining. Next slide. Employees would also have the right to representation. So for instance, before any employee is disciplined or has to address a complaint that has been received or an allegation concerning their competency, they would have a right to representation by the association to be present with them during a meeting with the management, with the administration. Now, this also includes that employees have a right to due process for situations involving discipline and often for competency or other situations where they would have the right to be heard prior to such action being taken by the administration or by a board. And with the right to representation, you'll also see that there are certain notice requirements that are generally outlined in contracts, but often they are not as well. And most contracts would have a notice requirement of 24 or 48 hours before a meeting is going to be taking place where representation will be needed. That's for the benefit of both the employer and the employee. In instances where it's beneficial to the employee, it would give them an opportunity to speak with their representative prior to the meeting and prepare for the meeting. For the employer, it would give the benefit of being able to arrange scheduling to address that a meeting will be taking place. Next slide, please. Employees also have the right to just cause in instances of, for instance, discipline. So before discipline can be administered, it would an administration or board is required to have just cause to do so. Now, we could effectively spend an entire day talking about just cause, but for purposes of this, just cause is effectively a legally sufficient reason to engage in the action that's about to be that's being engaged in. And a component of this is often that it can't be arbitrary or capricious, and oftentimes you'll see a requirement that the employee must have had prior notice that the conduct that they were engaging in was improper. That is also a component of just cause. With applicable only to teachers is a statute that has another component to the due process requirement, which is 16 VSA 1752. Which not only requires the right to be heard, but has the right to appeal to the board and have a hearing before the full board before action can be taken. That is a step that support staff and other school employees do not have. And what you see in the beginning here is that just cause applies except for probationary employees. So when an employee is on probation, oftentimes just cause is not required before action is taken by administration. Next slide, please. Often through contracts, employees will have the right to have any complaints against them be made aware to them and have them be investigated. With anything that's going to go into a personal file or any requirement that or any desire for an employee to review their personal file, they have the ability to do that. That's a retained right, both by statute, and you'll also see that in a lot of contracts. Next slide, please. Often another component of what you'll see in contracts is that employees have the right to see what's going to go in their contract before it goes in there. And they would have to either acknowledge or sign off or refuse, but they would have to have the opportunity to review it prior to any derogatory material going into their personnel file. Lastly, health and safety, and this has come up frankly more recently due to the instances of COVID, but you'll see in contracts language relating to health and safety and what would be an example effectively of what should be in a contract or what could be in a contract is that it's not a subjective standard, it's an objective standard of what is healthy and what is safety in terms of a working environment. And often, just for an example of how this has come up recently, is it safe to return to schools is often determined by the Agency of Health in Vermont as to what is safe and what isn't. So I'm going to turn it over to Chris next to talk about your salary schedules in your contracts.
Great. Thank you, Colin. If we could jump to slide 31, let me talk first about index salary schedules. Basically, there's two types of salary schedules that exist in Vermont for teachers. The first and most predominant are index salary schedules, and the other is a non-index schedule. And this slide shows an index salary schedule. And what you'll see in the first column on the left are the steps, and those represent years of experience for teachers. And those are called vertical movement. You know, a teacher progresses annually from step to step, from one year to the next. And then the next column over is the index. And this schedule starts out with an index of 1.0 at 41.5. And you'll see that this schedule, the increments of the index move in increments of 0.04 down. And then if you move two columns over, you'll see that horizontally they move over 0.05. And this schedule is called a 4x5, which means the increments are 4 down and they're 0.05 across. And so a teacher has the ability with education credits to move from column to column going down. One of the things about an index salary schedule is that the differential grows with time. And by that, I mean because it's indexed to a formula, what happens is that as you increase your base salary over time, the differential between your beginning salary and your maximum salary increases. So in this schedule, the differential is $38,595. And in 5 years or 7 years, that schedule, as money's put into it, that differential will increase. So it'll no longer be $38,600. It'll become $39,000 or $40,000 over time. And it will grow because it's an indexed salary schedule. On the next page, you see the exact same schedule, and it doesn't have an index at all. And this is a non-indexed salary schedule. It's flat dollars. And the increments in this schedule between steps were negotiated, and the increments in going from one column to the next column were negotiated. And basically in a non-index schedule, those increments don't change over time. So if you put more money into this schedule, what happens is you increase each of those steps, for example, by $200. But the differential between your maximum salary and your minimum salary doesn't change. And so one of the reasons why some people like a non-index salary schedule is that it maintains that differential between beginning and top salaries. And so you're able to offer new teachers more competitive starting salaries on a regular basis. If we could now jump back 2 slides, and I'll just quickly cover a couple of points. It's really important to understand your salary schedule and the costs associated with that, and be able to project what's the cost of step movement. And when I say what's the cost of step movement, I don't mean what's the dollar difference from one step to the next. I mean, if you advance every teacher on schedule, on step, how much money has that cost you? And if it's cost you $85,000, does that equal 1% total new dollars? That's important information to understand. You want to know what your FTE is per step, how many teachers you have on different steps. You want to understand the demographics of your staff. Do you have a majority of your teachers at maximum step, so they're not eligible for step increases? That affects the cost of schedule increases, and it also affects the dynamics at the bargaining table in terms of the interests of the union and what they need. You want to evaluate the sustainability of your schedule. A number of schedules in the state are still 5x5 schedules that have a 2.0 index. So if the base salary is $40,000, the maximum salary is $80,000. The 5x5 schedules are the most expensive schedules to maintain, and they were developed at a time when inflation was high single digits or low double digits. And consequently, if you're settling for 2.5% or 3% new dollars, and your step cost costs 2.75%, you have no money to put into your schedule. So it creates issues for you. And those are all considerations that the board needs to have in mind and be aware of when you're thinking about your schedule, when you're thinking about how you budget for negotiations, and when you think about strategy relative to bargaining salary schedules. And at this point, we're open for questions.
Okay, we have questions coming in. You mentioned in the timeline discussion, the finality step, stating that at that point, employees either strike or boards impose contracts, which may also result in employees choosing to strike. Could you address how a no strike clause, which I'll see in our existing contracts, affects the employee's ability to strike, and clarify the reasons behind including a no strike clause?
So a no strike clause only has value during the period of time that the collective bargaining agreement is in full force and effect. And so if you have a no strike clause and you're now talking about dealing with a strike or imposing a contract in the fall, but the contract expired in the spring on June 30th of that year, that no strike clause has no effect, and it doesn't limit the union's statutory right to go out on strike.
Okay, next question. Does every negotiation start with unreasonable salary demands from both sides? Is there a way to combat that?
I think that there's, go ahead, Colin.
I don't think every negotiation that I've been involved in has started with unreasonable salary demands on both sides. It really comes from practice and working together to know that you're trying to achieve a reasonable salary increase through negotiations. I think that's sometimes it happens, sometimes it doesn't. And if you're working with the same groups over a period of time and you're working well together, I think you'll often see that it doesn't continue. But Chris?
I think part of it's cultural. I work with some districts, and I would say at the start of the bargaining, the two parties are probably only about 2 percentage points apart in terms of their initial salary proposals. And I do work in other districts where the differential is 9 percentage points apart. And so I think it's cultural. I think it's relationships. I think some of it also has to do with what's the regional pressure in terms of the union's pressure for bargaining. In areas where there's a strong regional bargaining council, they try to, I think, come in with more unified positions in terms of salary proposals.
Okay, what is your feeling about including job descriptions in a bargaining agreement?
So I think that job descriptions in a collective bargaining agreement are really problematic when they're included, unless there's an express provision in the collective bargaining agreement that says that management, the school board, the superintendent has the ability to change job descriptions. Their presence in a collective bargaining agreement implies that they're negotiated, and that you don't have the ability to change them unless they're negotiated. And so I don't recommend it. I don't think it's necessary to do that. And I think it detracts from management's rights.
Great. All right. Thoughts on handling step/column movement when no new agreement. Oops, it goes further. When no new, let me start again. Thoughts on handling step/column movement when no new agreement at year end? I'm sorry. Does it make sense to you?
It does. So this is an area where if we were doing this webinar 25 years ago, the answer would be very different than it is today. 25 years ago, a majority of the school districts in the state, step movement was guaranteed from one year to the next, even if the collective bargaining agreement had expired. And that was based on a Vermont Labor Board decision in the early 1980s. Over the last 20 years, that's changed significantly. In a majority of school districts in the state, teachers do not receive step increases in the absence of, quote, a successor agreement. So if you don't have a new agreement, no automatic step increases. Of the districts that don't provide for automatic step increases, most of those provide for the teacher receiving column movement, but not a step increase. And with the districts that permit that, the rationale is that the teacher earns the column movement based on their educational credits, and that should be recognized. But there are still districts that provide that in the absence of no new agreement, a teacher receives no increase in salary whatsoever.
Great. We just have 2 more questions.
Right, Carrie, I'm just going to jump in really quickly. We
Sure.
do have 2 more questions. It is 12:58. So for those of you who are on the call, we'll keep these gentlemen long enough to answer those 2 additional questions. If you need to run, we understand that, and you'll get the responses to these last 2 questions in the email next week or later this week. Thank you.
Great. So the next question, if we have a 5x5 salary schedule where step costs 2%, do you have any suggestions for how to transition away from that?
You know, it's something that you ought to be working with your legal counsel about. There are a lot of strategies that a school board can employ. I think the part of it's really dictated by what's your regional data, where do your teachers fall on their schedules, what's their rank relative to the region. Frequently with districts where they're low in salaries on a regional basis, there's more of an incentive for the union to look at changing from a 5x5 to a 4x4 or a 4x5 or even to a non-index salary schedule. So it really depends on the individual circumstances.
Great. This is a little bit longer one. Given proposed changes to the state employee pension program, i.e. pay more and receive less, do you see this as a future negotiations issue? That is, will the association push to have local boards pay the difference in an effort to keep its members whole?
Colin, do you want to take that?
Sure, Chris. I think that that is a potential that associations could make that request. We obviously haven't seen it. This is a new issue, so we don't know how it's going to be addressed. It could also be addressed in a number of different ways of different levels of compensation. But because that local bargaining doesn't have the purview of covering retirement, that would be left. Questions specifically relating to retirement would be left to issues with the state and not to be controlled by collective bargaining agreement. But it could be any number of issues that we see raised to try to address that issue when the solution is reached. Obviously, the legislature hasn't reached a solution, so we don't know what it's going to be yet. But I think it's reasonable to assume that it's going to be addressed somehow, attempt to be addressed somehow by the associations.
In this cycle of bargaining where we've almost completed the bargaining after the first statewide healthcare agreement went into effect, for districts where teachers were paying 15% of the premium that have now been required to go to 20% as of this past January, in I think all of those districts, the union had a proposal at the bargaining table that essentially said, you need to make us whole and to give us a higher salary increase because now we're having to pay more for our health insurance as a result of the statewide agreement. I think you'd probably see something similar to that as a result of pension reform, again, depending on what happens.
All right, that's all of our questions.
Thank you
Chris
very much.
Leopold and Colin McNeil, thank you so much for sharing your expertise with the VSBA membership. And I think we have a few superintendents on the call as well. Always happy to have them. Thank you again. We'll be getting the handouts and the follow-up out to everybody who attended shortly. And in the meantime, when you sign out, please do take 2 minutes and complete that brief feedback so that we can make sure we're moving in the right direction. Thank you again, gentlemen. We very much appreciate it. Everybody have a great day.
Take
Thank you very
care.
much.